State having rested, are there any motions?
Your Honor, we would make under Rule of Criminal Procedure 3.3 a motion for judgment of acquittal in this matter. If I may argue from the seated position.
You may.
It'll be a little easier for me.
Go ahead.
Your Honor, we've got a case of Morgan v. State, which cites many cases for its proposition. It's a 5th District case. It's located at 127 Southern 3rd, 708. It's a 2013 case. And so this is why this case is unusual. To be honest with you, I was quite surprised that they were going to introduce Mr. Reeves' statement in this case, because normally, and I agree, this is what this case says. The question of whether a defendant acted in justifiable self-defense is generally a jury question. And that's normally because that first comes up when the defense does a presentation. What I was quite surprised that they did is that they put Mr. Reeves' statement in their case in chief. And that creates, I think, a problem for them. And this is why it creates a problem for them. That statement of Mr. Reeves has not been refuted by any single piece of evidence in this particular case, period. Let's look at what justifiable use of force is under the law, under both 776.012 and 776, as the court recalls, it refers us also to 776.013. And so I'm going to read those again because I think it's important for us to keep this in mind. A person is justified in the use of deadly force and does not have a duty to retreat if he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or to herself or another, or to prevent the imminent commission of a forcible felony. And so that's 776.012. As we know, there's a second section, which is B, which it says, under those circumstances also permitted under 776.013. So I'm going to read that. A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has the right to be, has no duty to retreat, and has the right to stand his or her ground and be forced with force, including deadly force, if he or she reasonably believes that it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. And we know that the law is clear that the danger does not have to be actual. So let's make that abundantly clear. I don't think the prosecution is going to disagree with this. The danger that Mr. Reeves perceived does not have to be actual. The only thing it has to be is that Mr. Reeves reasonably believed that he was in imminent danger from that observation. That is it. And so when you take his particular statement, it was 2 statements as the court recalled. There was a first statement that was about 30 minutes. There was a second statement that was much shorter. He laid out the groundwork that this was a self-defense case and that he was scared, and the reason that he was scared and that why he had to use his pistol and the fact that the phone was thrown at him, and the fact that those particular hands were coming in his direction. So let's talk about the phone, because clearly the phone is a deadly weapon. Hey, their lead detective testified the phone can be a deadly weapon, hands can be a deadly weapon, and both of those can kill. There's absolutely no doubt that there is evidence here that a phone was in between Mr. Reeves' legs immediately after he fired the shot that resulted in the death of Chad Oulson. Immediately, because we know that Mr. Hamilton came quickly over to Mr. Reeves' side, looked down, and there it was. It has not been refuted. It has not been refuted in this particular case that Mr. Reeves says, I think that that phone hit me in the head. That is an aggravated battery under any circumstance. You don't have to have serious bodily injury. You don't have to have any of that if you're throwing a deadly weapon to an individual and it strikes that individual. So we've got clearly an aggravated battery that has not been refuted under any circumstances. And we also have a regular battery. We have a felony battery on a person 65 years of age or older on 2 occasions. One occasion, obviously, is the throwing of the phone. The second occasion is when they grabbed the popcorn and threw that popcorn at Mr. Reeves. That's a felony battery. To To be honest with you, I'm sitting here and arguing this, but that's the law. I wish the law was a bit clearer, in differentiating, that particular, but it's a battery. If it's an unwanted touching, it's a battery. You know what else it is? And again, I almost feel a little silly arguing this, but it's a robbery. Because if you're threatening someone, and in the act of threatening someone, you grab that popcorn and you pull it and you throw it back at the individual's face, that is a robbery. Now, you don't even have to go there. You don't have to go to the robbery. In my opinion, you don't have to go anywhere, because we have clearly a phone being thrown that Mr. Reeves says hit him in the head, and it's been not refuted. If the prosecution tries to argue that it was refuted because nobody saw it, that's not refuting it. That's not refuting that particular fact. So, I think, Your Honor, and I'll be honest with you, I think the prosecution put themselves in a very bad position in placing that particular statement of Mr. Reeves, in trial in their case in chief. Because otherwise, we would be sitting here saying, okay, well, what do we have at the end of the day? We have a bunch of their witnesses saying this happened. No witness talking about self-defense. This is very unusual, and we were, frankly, yesterday very, very pleased that they did what they did, because I think now it's clear. Even in the light most favorable to the government, it is crystal clear that none of their evidence has refuted what Mr. Reeves said in that tape statement. So I would ask the court to grant us our judgment of acquittal. And by the way, on Nicole Oulson, whatever intent Mr. Reeves had in defending himself against Chad Oulson transfers to Nicole Oulson. So he can't be, at this point in time, guilty of the aggravated battery of Nicole Oulson either. And so it hasn't been refuted, Your Honor. I know that it's a tough decision for the court to make any time that the court is rendering a decision on a judgment of acquittal. But this record is crystal clear.
Thank you.
I have to agree with Mr. Escobar that this record is crystal clear. Unfortunately, I have to say it's crystal clear in the opposite direction. In taking the evidence in the light most favorable to the state, which of course is the burden at a judgment of acquittal argument, the state has put forth sufficient evidence to go forward to the jury on murder in the second degree as well as aggravated battery. I think Mr. Martin's going to handle the aggravated battery. It's kind of tied in just a tad with murder in the second degree. All the elements of murder in the second degree have in fact been proven. We have that Chad Oulson was dead. It was done by the criminal act of the defendant, and it was done through an act that was imminently dangerous to another, evidencing a depraved mind with ill will, hatred, spite, or evil intent. I have some case law if the court wants to read it, just about those other elements, but I don't think based on the arguments it's necessary. Really what the defense is indicating is that the state has to somehow rebut the defendant's allegation of self-defense, and because every single eyewitness indicated it didn't happen, somehow we have to accept the defendant's word. And I'm having a hard time wrapping my head around that. The evidence in this case is that every single witness that we called said the defendant's version of events simply didn't happen. There's a video and evidence that the court has reviewed and has seen in the past, and it's been played again during this trial, that absolutely, with 100% certainty, contradicts the defendant's story. There's a case that I can cite, and I can also present a copy to the court. It's Leisure. And I will, may I approach?
Yes.
It's a copy for defense counsel. It's Leisure, 105 Southern 3rd 5. It's a second DCA 2012. And basically what this case states is that the jury can outright reject any claim by a defendant. And we've put forth sufficient evidence, especially at this juncture, just that we're arguing about a judgment of acquittal, to rebut the defendant's allegations. There's some I guess the defendant, according to the defense's argument, was definitively struck by a cell phone. The court would recall there has been no testimony or evidence of that whatsoever. In fact, the defendant himself doesn't know if he was hit by a phone. He says it might be possible, and the reason I think it might be possible is because, well, something happened, and I looked down at my feet, and there's a cell phone. I'm putting two to two together. I guess it was a cell phone. Looking at it logically, and there's no secret in this case about this, had the defendant been struck with a cell phone, I think it'd be reasonable, and especially for an argument of JOA, that there would be some form of injury. Now, this some form of injury certainly isn't this left corner of the eye or eyelid injury, especially if it's being used as a deadly weapon. The definition of a deadly weapon is as follows, and I'm sure the court knows this. A weapon is considered a deadly weapon if it's used in a way, I'm going to try to slow down. I get going, I get fast. If it's used in a way likely to cause death or great bodily harm. So a cell phone, in and of itself, is not a deadly weapon. It's the manner in which it was used. If he were to toss a cell phone, that wouldn't be an aggravated battery. That would be a battery because it touched or struck him against his will. Because he was over 65, it would be a felony battery, which is going to be my other argument. So if the court needs a copy, I can give the court a copy. I'm sure the court's aware of this. There's different standards within the self-defense instruction. There is an applicable forcible felony section, but there's just another section that only talks about the generic felony. Okay? In that section that talks about just the generic felony, I'm going to read it because I don't want to misquote it. It says, the use of deadly force is justifiable if the defendant reasonably believed. Let me stop there just for the JOA argument. There is no evidence at all that would support the defendant's contention that he reasonably believed at the time of the shooting he was going to die. I mean, that's basically what the instruction states, imminent death. So there is absolutely no evidence that at the time he fired that shot, he could reasonably believe he was about to die or suffer great bodily harm. At the time the shot's fired, there is no way in the world, based on the evidence presented through the witnesses in the video, he reasonably believes he was about to suffer great bodily harm. That's what the instruction states. So the use of deadly force is justifiable if the defendant reasonably believed. I submit all the evidence so far shows he certainly did not reasonably believe it. But anyway, going on, believed the force was necessary to prevent imminent death or great bodily harm while resisting. He's not resisting anything. And then it talks about an attempt to commit a felony upon him. So let's say the felony that's being suggested, which was what Mr. Escobar was arguing, is battery on someone over 65. It was over. He's not resisting anything. What happened was, his popcorn was tossed on him. That was done. Mr. Oulson's hand was coming back. The act was complete. There's nothing he's resisting. It was done. And he decided, based on the evidence, that he was going to shoot and kill him at that point. So he wasn't resisting anything at that point. The robbery conversation, or I guess argument that Mr. Escobar made, the defendant himself states in his own taped statement, when Mr. Oulson jumped up, the popcorn went by the wayside immediately. I don't know if it fell out of my hand or if he knocked it down. I don't know. There is no robbery. There was no force, violence, assault, security, and fear that he was aware of. So that certainly wouldn't apply. And that's going to end up being my argument later on when we get to jury instructions. In the case that I presented to the court, it states, and I've already alluded to it, and this case is even better for us than the argument I'm advancing, because in that case, the leisure case, it states, even when there are no other witnesses to the event beside the defendant, because a lot of times there's a homicide and the only witness is the person who has passed away, a jury is not required to accept the defendant's testimony to support his or her self-defense theory as true. It must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. Leisure's numerous inconsistent statements cast significant doubt on her assertions. And that's exactly what we have here, except for the fact that we have multiple witnesses who are saying what the defendant's stating took place didn't happen. And even if you discount all of those witnesses, the video indicates that it never happened. So there is no justifiable use of deadly force here. because at the time of the applicable battery, he wasn't resisting anything. But even if that argument was to be made, he could not, based on the facts and circumstances introduced in the evidence so far, reasonably believe that killing Mr. Oulson was necessary to prevent his own death or great bodily harm occurring to himself. The facts, just real briefly, for just other elements, is that there has been a period of time within which that the defendant could develop animosity towards Mr. Oulson. It was about 4 minutes between the initial encounter and the time of the shooting. And again, there's absolutely no evidence whatsoever that this was a lawful use of deadly force, and therefore I would argue that the defendant's motion for judgment of acquittal should absolutely be denied.
Judge, if I may just have a couple of points here.
Okay.
Again, I think that, their problem, they're talking about this video. This video supports us. It doesn't support them. If you look at the video, you'll see that about 8 to 10 seconds before the actual grabbing of the popcorn and throwing it back, you actually see Mr. Oulson actually coming over the seat with a hand. It is at that time that Mr. Reeves, in his statement, is saying, hey, listen, I see him coming over. And you can see it on the video. Take a look at it if you like. We've got it in circles, that our expert has actually circled that particular area. It was at that point in time that Mr. Reeves says, hey, listen, I believe that he hit me either with a phone or with a fist or something, but it hit me on my face. It knocked my glasses askew, and I was a little bit dazed at that point in time. That is an aggravated battery that has not been refuted. Guess what? There's not a single witness that they presented in this trial that refutes that. But then there's a second. Then what happens is about 8 to 10 seconds thereafter is when the hands start coming through. And I want you to look at the fractions of a second that it takes for the shot to take place. It's fractions of a second. It is an absolute impossibility for Mr. Reeves to have shot Mr. Oulson because of popcorn. It's a human impossibility. But it doesn't matter because of the fact that nobody has refuted what Mr. Reeves said in that tape. Frankly, when we went home last night, we were shocked that they had put those audios in because they were good for us. We were going to sit here on a judgment of acquittal and say, okay, well, Judge, we have a judgment of acquittal, and that's my argument. But when they put that in, I thought that they had made a huge mistake, and they have. Think of the witnesses that were presented before this court. Nicole Oulson didn't see anything, okay? Nothing whatsoever. Mr. Cummings doesn't refute what Mr. Reeves says in his statement. Certainly Mr. Hamilton doesn't because he's only seeing silhouettes, okay? And certainly the lead detective doesn't. There is not a single witness that they've presented that refutes Mr. Reeves' statement in that oral tape, in that recorded tape. Nothing. And so what does that do? If you look at the Leisure case that they're talking about, I think Leisure, that motion of a judgment of acquittal that they're talking about happened at the end of both the state and the defense case. We're talking, and the case that I'm citing here, and we'll give a copy, let me have a copy to the court. Some of the language is not good because normally in situations like this, may I approach?
2 minutes.
More. And can you give one to the state? Normally, Your Honor, in these situations, if you look at Morgan starting on page 8, I'm going to read what the court says. The question of whether the defendant acted in justifiable self-defense is generally a question for the jury. I agree with that. It's a Supreme Court case that they're citing, Rimmel versus State, located at 532 Southern 2nd, 16. However, look what it says at the very bottom. However, a motion for judgment of acquittal based upon self-defense should not be granted unless the evidence is such that no view which the jury may lawfully take of it favorable to the opposing party can be sustained under the law. And the law, again, is the danger doesn't have to be real. It only has to be reasonably perceived by Mr. Reeves. They have not one scintilla of testimony that refutes his version on that. And so they're stuck with that particular tape. They put it on. They didn't put anything on to specifically refute his perception, and therefore the court has to take that perception what it is, because it hasn't been refuted. And this jury can't do anything with it because there's no evidence to contradict it. So I would ask the court, again, to look at 776.012, 776.013, and understand this. The law does not punish one that reasonably believes that they need to use that force to protect themselves against great bodily harm or death. They don't have to be right. They just have to reasonably believe. There's a big difference. That's the beauty of this law, because you can make a mistake in that whole process, and the law still is not going to punish you as long as you reasonably believed at that time. And we've got Mr. Reeves talking about his law enforcement career, talking about what he has done in that particular area that, again, was never refuted. And they didn't bring in any police officers to say, hey, Mr. Reeves wasn't a very good police officer. He didn't know anything about use of force. He was not commander of the SWAT team. He didn't know it. Just the opposite. They were silent on that. And so, Your Honor, respectfully, we're looking at every single witness here. They haven't refuted this, and they're stuck with that recording.
Thank you. All right, as far as the statement played of the interview of Mr. Reeves, I found that there was a great deal of evidence that refuted some of his statements. For instance, the whoa, 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 ho, no, no, no. Pretty much every witness that claims to have heard or seen something said they didn't hear that. And I know you've said several times now since the beginning of the trial about the 10 seconds prior in the video. It's clear to see that the defendant came over the decedent came over the chair and, was taking a swing or something at Mr. Reeves. I didn't see that. I looked hard as I could look, and I did not see that in the evidence that's before me at this point of the trial. So I think that evidence refutes the claim that there was the first attack, that it's been called, and the lack of any marks, that somewhat, but I agree with defense that wouldn't be enough on its own to refute that. But even in Mr. Reeves' own statement, he says in the second part that he's not sure. He's not sure if he got hit. He's second guessing himself. And I think with all of the evidence that's been presented, the state has overcome the motion for judgment of acquittal. I'll deny. All right, what else do we need to talk about today?
Judge, the only judgment of acquittal I heard was for second-degree murder, so...
Oh, sorry. Yeah.
We argued for both.
Yeah, and this thing, you correctly identified the fact that with transferred intent, if you prevailed on the judgment of acquittal as to the second-degree murder, I think that would apply to the aggravated battery. And you probably disagree, but
No.
okay.
It doesn't.
Right, okay. I don't. I think,
I think we
okay,
agree on it.
okay.
All right. Do you need any further arguments, then I'll count?
No, I'll deny the motion in its entirety as to both counts. All right, do we have any other smaller motions that are still outstanding?
We're going to try to make them smaller later.
Okay, the main ones regarding the experts.
Yeah,
Okay, I thought that was all we really had outstanding.
yeah. We'll do the heavy lifting.
Okay.
Outside the courtroom and see if we can narrow it down for the purpose.
All right. There's a lot of case law, on these issues, so hopefully you can do that.
Well, it's not going to be much more than that 100-page doubter motion I filed in the quality case law. So if you read that, you know what the case law is as far as the state's concerned. So that's what the state will be relying on.
Okay.
And Judge, I think we've got, 5 witnesses who will be here tomorrow.
Okay.
So I think that should hopefully, Smith is going to be long.
Yeah, I
and so
figured.
I'm thinking 5 to do our presentation.
Okay.
We'll see if maybe there's we'll get you a list, absolutely. We will see if maybe we can even squeeze in a 6th if we find someone that's available.
Okay.
We normally were supposed to give them a day ahead notice.
Right.
So
They appreciate that.
We got 5, for
Okay.
sure.
If they're local and, retired or can get off work or whatever, but
There seems to be a lot of retired people in this case.
fortunately so. All right, so how are we looking then for time, realistically?
I think it's going to take us next week.
Do you think you can be done by Thursday?
We will try our best. I can tell you more tomorrow, we'll talk about it. I
Okay.
think, we'll
Yeah,
what
see
the
how
lineup is
tomorrow
gonna be
goes,
for,
yeah.
For Monday and Tuesday.
Mm-hmm.
And see if we can get our list of witnesses. I'd like to try to, put as many witnesses, quickly. The problem that we have is we have Dr. Foley, who is a practicing radiologist, so we're gonna have to fit him in somewhere. And we've got our Jacksonville expert that,
Is that
coming from
Dr.
Jacksonville.
Cohen
That's a Knox.
or Knox? Okay.
And there's still an
Coding is
issue.
easy.
There's still an issue with Mr. Knox because of my doubter motions haven't heard on him.
Okay.
So, and
Right.
it was at the during trial, so.
Right, I know. So,
But
yeah,
the
that's,
transcripts, you got the transcripts.
I do.
Right, and you have, I think both sides have thoroughly briefed the issues.
Yes, you have.
So.
Yeah, so
If
hopefully,
the court has read and absorbed that, then the court's decision
yeah,
with the testimony should.
hopefully we can get that with minimal delay. But yeah, that certainly will help, the fact that you've briefed thoroughly and I've read the transcripts, so,
Because my argument's not going to be any more than what's in there.
okay. All right. We'll keep our fingers crossed. All right, well, I guess we'll have an early day today then. I'm sure none of us mind that.
We welcome it.
I'm telling you, and I just want to take the opportunity, thank you all. So far, so good. Everybody's been doing a great job. It's a tiresome job on you guys' part, but you've all done really well, so
Thank
I
you.
appreciate that. Thanks. All right, we'll see you at 8:30 in the morning then. Thanks, everybody.